Employment Law Training for Supervisors. Introduction and Training Overview. Overtime pay, discrimination, medical leave, harassment, and accommodations. Federal employment laws govern all of these issues and many, many more that you may face in your career as a supervisor. Supervisors have shared responsibility with human resources in making sure that interactions and relations with employees are compliant with federal and state employment laws. Today's training is intended to provide you an overview of the most important employment laws that supervisors need to be aware of and the major responsibilities that supervisors typically are responsible for in ensuring compliance. It is important for you to understand the basis of how to comply with these laws. You will receive a written handout with today's training video containing the pertinent employment laws and the definitions. Please feel free to take notes as we move through the topics. Training agenda. The topics we will cover in today's training are the Fair Labor Standards Act of 1938, Title VII of the Civil Rights Act of 1964, Americans with Disabilities Act of 1990, the Age Discrimination in Employment Act of 1967, Sexual Harassment, Family Medical Leave Act, or FMLA, Occupational Safety and Health Act, the National Labor Relations Act, Immigration Reform and Control Act of 1986. The Fair Labor Standards Act of 1938 is legislation that gave American workers a minimum level of income security. The FLSA, often referred to as wage and hour law, because that is what it defines. The Fair Labor Standards Act, or FLSA, is the nation's main wage law and is enforced by the Department of Wage and Hour Division. It sets the federal minimum, however, many states have higher minimums, and requires time and a half overtime pay for hourly employees who work more than 40 hours in a work week. The FLSA also limits the hours and types of duties that teens can work. Prior to the passage of FLSA, there was no limit to the number of working hours in a day or in a week that employers could require of their employees. In addition, there were no requirements for minimum compensation for an employee's work. Therefore, an employer could require employees to work for as many hours as they could get out of them and pay employees as little as possible. This potential exploitation of labor was restricted by the FLSA, whose purpose was to establish minimum labor standards on a national level and to eliminate low wages and long working hours. There has always been some confusion on the part of employers and employees as to who is qualified for overtime and who is not. The FLSA identifies two categories of employees. Non-exempt employees are covered by the overtime provision of the FLSA. Exempt employees are not qualified for overtime under FLSA. The FLSA, as amended in 2004, identifies exempt employees as employees in the following roles: executive, administrative, professional employees, outside sales, and employees in certain computer-related occupations. Your responsibilities. Supervisors are tasked with reviewing and approving non-exempt employee time cards. It is your duty to ensure these employees are paid properly in adherence of the FLSA regulation. Non-exempt employees must accurately record overtime worked for our organization to remain in compliance. Additionally, supervisors and managers should understand which roles fall within the exempt and non-exempt categories. Please work with your human resources business partner before altering your employees' essential duties, as this could impact their exemption status. ABC Company believes it is good business practice to have a diverse workforce that reflects the communities in which we live and serve. We view the principles of equal employment opportunity as a vital element in the employment process and good management practice. Federal law guides these practices, and ABC Company is committed to full adherence. Furthermore, our organization has an affirmative action plan available for review. Equal opportunity and commitment to diversity. Title VII of the Civil Rights Act of 1964 deals specifically with discrimination in employment and prohibits discrimination against any individual on the basis of race, religion, color, sex, including pregnancy and gender identity, sexual orientation, parental status, national origin, age, disability, family medical history or genetic information, political affiliation, military service, or any other non-merit-based factor. The law also protects individuals from harassment in the workplace. The Act covers all employers having 15 or more employees except private clubs, religious organizations, and places of employment connected to an Indian reservation. Your responsibility. Supervisors must treat all employees and applicants consistently and equally, without regard to their race, color, religion, gender, national origin, or any other characteristics that are protected under the law. Supervisors are not to base any employment decisions on these protected characteristics, cannot deny opportunities to an individual because of their characteristics, and cannot retaliate against an employee. Supervisors are to treat all employees respectfully and avoid unwanted, unwelcome behavior that constitutes harassment. Please direct all questions to your human resources manager if you believe discrimination has occurred. All reported allegations of harassment, discrimination, or retaliation will be investigated promptly, thoroughly, and impartially. The Americans with Disabilities Act of 1990, ADA, prohibits discrimination based on a disability. The ADA provides that qualified individuals with disabilities may not be discriminated against by private sector organizations or departments or agencies of a state or local government employing 15 or more employees if the individual can perform the essential functions of the job with or without reasonable accommodation. The law requires an employer to provide reasonable accommodation to an employee or job applicant with a disability unless doing so would cause significant difficulty or expense for the employer, which may be considered an undue hardship. Reasonable accommodations are determined on a case-by-case basis and may include reassignment, part-time work, and flexible schedules. An accommodation may also include providing equipment or modifications to a workstation. Your responsibility. As a supervisor, you may be the first point of contact for an employee requesting an accommodation. However, it is equally important to recognize the need for a reasonable accommodation as well as address the employee's requests for that reasonable accommodation. Supervisors play a key role in the interactive process of discussing what accommodations may fit the individual. Supervisors must also address the day-to-day management and administration of employee accommodations, such as flexible schedules, assignment modifications, etc. In addition, supervisors often must work with HR to identify the essential functions of a job, which aid the ADA compliance process. Be sure to have a proactive conversation with your HR business partner should you have questions about your responsibilities. If an accommodation request is made by an employee or a candidate, you will need to engage human resources. The Age Discrimination in Employment Act of 1967, ADEA, prohibits employment discrimination against anyone at least 40 years of age in hiring, promotions, wages, benefits, or terminations. Your responsibility. Never take a person's age or proximity to retirement into account when making decisions on hiring, firing, pay, benefits, or promotions, training programs, and any terms or conditions of employment. Supervisors must never assume that older workers can no longer do a particular task or job, communicate in a way that implies bias, replace older workers with younger ones for illegitimate reasons, or discipline workers more harshly. Be sure to communicate any concerns with your HR business partner. All reported allegations of harassment, discrimination, or retaliation will be investigated promptly, thoroughly, and impartially by your HR business partner. The Equal Pay Act, EPA. The Equal Pay Act prohibits employers from gender pay differences. The EPA law says employers cannot pay female employees less than male employees for equal work on jobs that require equal skill, effort, and responsibility. Your responsibility. Review department pay scales to identify possible equal pay complaints. Different pay for the same job title may be permitted if the roles vary in levels of responsibility, duties, skill requirement, or education requirements. Please speak to the Director of Compensation and your HR business partner when researching specific concerns in your department. All reported allegations of harassment, discrimination, or retaliation will be investigated promptly, thoroughly, and impartially. Sexual harassment. Under Title VII of the Civil Rights Act of 1964, sexual harassment is illegal since it constitutes discrimination with respect to a person's condition of employment. It is unlawful to harass a person, an applicant, or employee because of the person's sex. Harassment can include sexual harassment or unwelcome sexual advances, requests for sexual favors, and other verbal or physical harassment of a sexual nature. Harassment does not need to be of a sexual nature, however, can include offensive remarks about a person's sex. For example, it is illegal to harass a woman by making offensive comments about women in general. Both victim and the harasser can be either a woman or a man, and the victim and the harasser can be the same sex. Although the law doesn't prohibit simple teasing, offhand comments, or isolated incidents that are not very serious, harassment is illegal when it is so frequent or severe that it creates a hostile or offensive work environment, or when it results in adverse employment decisions, such as the victim being fired or demoted. The harasser can be the victim's supervisor, a supervisor in another area, a coworker, or someone who is not an employee of the employer, such as a client or customer. The Equal Employment Commission has published guidelines for employers dealing with sexual harassment. According to these guidelines, sexual harassment is defined as unwelcome sexual advances, requests for sexual favors, and other verbal or physical conduct of a sexual nature when submission to such conduct is made either explicitly or implicitly a term or condition of an individual's employment, or submission to or rejection of such conduct by an individual is used as bias for employment decisions affecting such individual, or such conduct has the purpose or effect of unreasonably interfering with an individual's work performance or creating an intimidating, hostile, or offensive working environment. Your responsibility. Associates who have complaints of sexual or other harassment or discrimination by anyone at work, or who have witnessed or are aware of harassment or discrimination of another, whether by a manager, coworker, customer, vendor, or visitor, must report such conduct to their supervisor, senior leader, or to human resources. All reported allegations of harassment, discrimination, or retaliation will be investigated promptly, thoroughly, and impartially. As a supervisor, all reports and witness to harassment must be reported to Human Resources for immediate investigation. Family and Medical Leave Act, FMLA, entitles eligible employees of covered employers to take unpaid, job-protected leave for specified family and medical reasons with continuation of group health insurance coverage under the same terms and conditions as if the employee had not taken leave. Eligible employees are entitled to 12 work weeks of leave in a 12-month period for the birth of a child and to care for the newborn child within 1 year of birth, the placement with the employee of a child for adoption or foster care and to care for the newly placed child within 1 year of placement, to care for the employee's spouse, child, or parent who has a serious health condition, a serious health condition that makes the employee unable to perform the essential functions of his or her job, any qualifying exigency arising out of the fact that the employee's spouse, son, daughter, or parent is a covered military member on covered active duty, or 12 or 26 work weeks of leave during a single 12-month period to care for a covered service member with a serious injury or illness if the eligible employee is the service member's spouse, son, daughter, parent, or next of kin. Your responsibility. Please contact Human Resources and the Benefits Coordinator immediately upon receiving an FMLA request. As a supervisor, you must listen for requests that would meet the FMLA criteria, such as references to health condition or family member's health condition, since employees don't need to use the words FMLA to gain protection under the law. Supervisors are to maintain contact with the employee on leave and remain informed of changes to their condition or leave and communicate those changes to Human Resources. While employees are on leave, supervisors must be cognizant of employment actions, including termination, discipline, etc. Finally, supervisors also need to follow privacy, confidentiality, record keeping, and other FMLA-related responsibilities that our organization has in place. Occupational Safety and Health Act of 1970, OSHA, is the primary federal law which governs occupational health and safety in the workplace. It ensures that employers provide employees with a safe and healthy work environment free from recognized hazards such as exposure to toxic chemicals, excessive noise levels, mechanical dangers, heat or cold stress, or unsanitary conditions. OSHA is responsible for establishing and enforcing occupational health and safety standards for inspecting and issuing citations that violate these standards. OSHA standards are the rules that describe the methods that employers are legally required to follow to protect their workers from hazards. Specifically, the purpose of OSHA is to accomplish the following: encourage employers and employees to reduce workplace hazards and to implement new or improved existing safety and health plans, provide for research in occupational safety and health to develop innovative ways of dealing with occupational safety and health problems, establish separate but dependent responsibilities and rights for employers and employees to achieve better safety and health conditions, maintain a reporting and record-keeping system to monitor job-related injuries and illnesses, establish training programs to increase the number and competence of occupational safety and health professionals, develop mandatory job safety and health standards and enforce them effectively, provide for the development, analysis, evaluation, and approval of SAT occupational safety and and health programs. Failure to comply with OSHA standards and/or safety violations may result in hefty fines for an employer. Serious, willful, and repeat violations have fines attached ranging from $7,000 to $70,000 per violation, with additional fines tacked on for each day a violation continues. As a result of workplace accident, injury, or illness, employees are covered by workers' compensation. Workers' compensation is a federally mandated insurance program developed on the theory that work-related accidents and illnesses are the cost of doing business and that should be paid for by the employer and passed on to the consumer. Your responsibility. Supervisors must provide employees with a work environment that is free of recognized hazards that could cause serious physical harm, and also need to comply with occupational safety and health standards. Supervisors are also responsible for ensuring that employees receive safety training, assessing hazards in the work area, determining the type of protective equipment needed, investigating incidents and inspecting equipment, and reporting all accidents and injuries that employees have at work. It is your responsibility to alert the Health, Safety, and Environment team when a hazard is uncovered. Remember, it is always better to err on the side of caution. Please report any and all potential safety hazards or violations. Should an employee be injured, fall ill, or be involved in a workplace accident, an investigation of the work area must be conducted. Human Resources and HSE will assist you with the documentation and provide guidance on the investigation. Report all incidents immediately. The National Labor and Relations Act, NLRA, defines the rights of employees and employers, including their right to collectively bargain and engage in concerted activities such as grievances, strikes, and so on, for the purpose of collective bargaining or mutual aid protection. Your responsibilities. Supervisors need to understand employees' rights relative to the NLRA, specifically to engage in collective bargaining and protected concerted activities, such as complaints about unfair labor practices. Supervisors are prohibited from taking adverse action against employees who engage in such activities, such as discrimination, retaliation, interference, or restraint. If an employee or labor representative contacts you about union organization, please refer that individual to Human Resources. Immigration Reform and Control Act of 1986 requires every U.S. employer, regardless of size, to verify the employment eligibility of its employees. This task is accomplished by completing Form I-9, which attests to the legal status of each worker. Financial penalties for noncompliance can be harsh. Fines range from $1,000 to $100 per employee. Fines range from $100 to $1,000 per employee. Beyond financial repercussions, employers may face criminal penalties as well. Immigration and Customs Enforcement, ICE, and the U.S. Attorney's Office have made individuals who work for companies that employ illegal aliens the targets of criminal prosecutions in recent years. HR professionals and line managers have been handed prison sentences for conspiracy and harboring illegal aliens. Our company participates in E-Verify, a free internet-based program run by the U.S. government comparing data from an employee's Form I-9 with government records. If there is a match, the employee is eligible to work in the United States, whereas a mismatch alerts an employer and the employee is then allowed to work while attempting to resolve the reason for the mismatch. E-Verify is run by the Department of Homeland Security in partnership with the Social Security Administration. Your responsibilities. As a hiring supervisor, there may be times you are required to complete a Form I-9. It is critical you obtain approved documents from the employee and complete the I-9 prior to the third business day the employee begins working. While the government allows for 3 business days to complete the I-9, it is our policy the authorization and E-Verify be completed on day 1 during on-site orientation. If there is need for an exception to this timeline, you must contact the Director of Talent Acquisition to discuss. You will receive separate training on how to execute an I-9, permitted documentation for an I-9, and the E-Verify process. Your Human Resources business partner is available to field your employment law questions and concerns. Supervisors and managers should understand the basic conditions of federal and state law governing employment relations between employee and employer. ABC Company hopes today's training provided a comprehensive overview into the employment laws you as a supervisor manager must be aware of. Together with your human resources team, ABC Company aims to remain compliant and treat each of its employees fairly within the confines of the law. Please be sure to discuss any questions you have with your human resources leadership. Your HR business partner is assigned to your division to assist with the laws outlined in today's training and any other employment-related concerns that may arise. Thank you for your time and attention during today's training.